let's talk about the first trust that you talked about. Is that a one-time change in, or can you make changes? For example, in my case, my kids are, when I did if I were to put it in the asset protection trust, now my kids are older. Some of my kids are involved in our business. Is that a one-time change you can make, or is that something you can make multiple times?
You can make it multiple times. And so
Okay.
if we're just doing it for asset protection purposes, we'll structure it as an incomplete gift, which means that you still look at it as
In process.
So there's kind of two ways to structure it, right? So if you have a very large estate and you say, okay, well, the estate tax exemption is $12 million. I want to kind of use up my exemption before it goes away. Then you can gift it to an irrevocable trust that's kind of treated like its own separate entity. But if we're doing it for asset protection purposes, we do it as an incomplete gift. So you retain all these powers, so the IRS still looks at you as the owner of that property. And so you, every year, or even more frequently, you could go in and you could exercise that power of appointment to change the beneficiaries. But usually it's limited to your descendants and spouses, because if you have this completely unfettered ability to change the beneficiary during your life or upon your death, let's say, well, come on, this is essentially just a revocable trust because you can do whatever you want. So there are some.
They're going to call BS.
Yeah, they're going to say, come on now.
Okay.
So.
All right. So it's a lineal, or can it be?
It's usually descendants, your spouse, and then the spouses of your descendants.
Well, let's talk about that, because we deal a lot with, for example, IRAs, self-directed IRAs and 401ks. And again, they will not allow for lineal descendants to be involved in those, but they will allow for cousins.
Oh, interesting.
And they will allow for father-in-laws, as long as they're not directly blood related. So many of the people that we help as brokers, they've got stepkids and family that is not related by blood. How do you deal with that?
Well, on a more basic level, right, we have the blended families. Each spouse has their own set of kids. And so when we're meeting with the clients, we're going to talk about, okay, well, what powers are we going to give the surviving spouse? So sometimes we'll do what's called the survivor's trust. We just say, okay, well, whatever's in this trust, when the first spouse passes away, it all goes to the surviving spouse, and that surviving spouse can amend, revoke, use, enjoy, do whatever they want. Even if it means that they, after the first spouse passes away, the survivor says, well, you know what, my husband's kids don't really call, they don't really come around, and it's been about 10 years. So you know what, I think I'm just going to amend this trust just to have everything go to my kids. And we see that a lot. Or we see that, throughout the marriage, second marriage, we're married 30 years, you each have your own kids. They say, well, no, there are all these kids, they're both of our children. But then when it comes down to sit down and write out the estate plan, that kind of shifts a little bit. They're usually favor their own children. One remedy is something that we have what's called an A-B trust. We say, okay, when one spouse passes away, we're going to take the assets that are in this trust and we're going to split it into two shares. We're going to say, okay, the surviving spouse can take their half. They're going to put that into what we call an A trust, where they can continue to be the trustee, amend, revoke, use, enjoy, give it all the way to charity, travel around the world, do what they want with it. But we're going to take the other half that belongs to the spouse who passed away first, and we're going to put that into this B trust. That B trust is going to be irrevocable. So yeah, maybe the surviving spouse can still use the money for their needs. Maybe they could still be the trustee, or maybe they're a co-trustee, but they can't change those beneficiaries. We've kind of locked in the children of the first spouse to die as the ultimate beneficiaries of that share. And so some clients like that idea, but then sometimes we explain there's some administration there, and you don't know which spouse is going to pass away first. So we don't know which spouse we're imposing these limitations on. So sometimes the spouses just look at each other and say, oh, I trust you and you trust me, so let's just let's do the survivor's trust. And I know you won't disinherit my kids and I won't disinherit yours. And we find out sometimes that's not the case. We had an unfortunate case recently, actually. The gal came in, her husband had already passed away. I'd never met him, never met her kids. She said, okay, I want to trust. And I said, okay, well, who are our beneficiaries going to be? Well, she gave me some charities. So we set up the trust. Little did I realize that her husband had several children. and she did not provide for them. So when she ultimately passed away, they came knocking like, well, hey, that house was originally our dad's. All that money originally came from our dad. And so they were pretty upset that when their stepmom passed away, she just gave everything to charity. And so sometimes we have to have a very, candid, straightforward discussion with the clients about, the potential risk of what could happen based on the way that we set up the trust.
Sure. Well, in real estate, one of the common ways that people purchase is they do tenants in common.
Yes.
And I'll talk about that. And I think that might kind of go along the same lines of having your property share go to people that you never intended.
Well, so there's usually two. I mean, if you're buying a piece of property with maybe a family member or just a friend you're both kind of putting money together to buy the property, there's multiple ways to do that, right? So there's tenants joint tenants with right of survivorship. So that means that whoever is the surviving joint owner, they receive all of the property. And then you have tenants in common, where it says, okay, if I pass away, my half just goes either by the laws of intestacy or it goes according to my will, and then my partner keeps his or her share and they can do whatever they want with it. And so what we end up having is, well, okay, it's tenants in common. I pass away. My wife is the executor and the beneficiary under my will. And now my partner has a new partner who they may or may not want to do business with.
Right.
Maybe that my spouse is a difficult partner. She's difficult to deal with. She doesn't want to sell. She doesn't want to, sign documents to get the property refinanced. She's not interested in reinvesting the money. And so that can be problematic. And so sometimes when we have a business, such as a commercial real estate venture, we've got unrelated partners. A lot of times we'll do like a buy-sell agreement where we say, okay, you know what, if I pass away, my partner is going to get my half of the business, but then I've got this life insurance policy here that the business has been paying on, and then my family will get the life insurance proceeds. So they've got liquidity, they've got a legacy while the business goes over to the other partner. That's very common.
Yeah, well, and I've seen it where you have people who have conflicting interests, where in the tenants in common kind of scenario where you have, for example, like in a service business where the sons of one and the sons of the other, these guys don't want to be in the business, but these ones do, and they don't have it set up so that the sons that are actually in there doing the sweat equity, the ones that are actually working the business, are paying money and dividends to the people who have nothing to do with the business. And it causes so much heartache. So this is something you really want to make sure that when you're starting this venture, that you have that conversation up front. What's going to happen?
Or even within the same family.
Right.
We see businesses where mom and dad started the business, or maybe just dad, and he's got 3 sons, bringing in the first 2 sons into the business. They're getting a salary. They're working the business. They're making it grow. But then the estate says that everything's split equally, right? And so you've got two sons, or they're going to end up with a third of the business, and they're in the business working it. And this other son is not in the business, but he wants them to sell it, or he just wants them to give them money, and maybe it doesn't make financial sense. Or the one who's not in the business says, well, why are you giving yourselves a $250,000 salary every year when that could be a net profit, or that could be a dividend to me on the outside as just a shareholder in that business? And so that can create some conflicts where it may have been better, maybe in a trust or a will, to dictate exactly what was going to happen with that business interest. Say, okay, well, maybe we just give the business to the kids who are working it, and then give cash or give other assets to the child who's not inside of the business, so that we don't have those conflicts. I've got one client right now. He's got a business, he's got 2 or 3 kids in it. He's got a total of 10 children. And so he's conflicted about, how to divvy that up. Who's going to receive?
How many kids?
10 children.
Okay.
He's also into development real estate. So he's like, okay, which children receive these, real estate holdings, which ones receive the business, and maybe they're not of equal value. So how do we equalize that? So sometimes we have to sit down, do valuations, and just kind of map out each each asset and how we're going to deal with it. So that's why when a new client comes in and calls me to do an estate plan, we'll usually send them out an intake. So can I list all the family information, list all the assets. So as we're going through the estate planning process, we're dealing with each and every asset and talking about how that's going to be part of the overall estate plan.
Sure. What about intellectual property and royalties and those kinds of things? For example, I'm getting ready to write, I'm in the process of writing books where there is a potential for ongoing royalties that would come as a result of that.
So we deal with a lot of that, especially being in Nashville, Music City. We've got a lot of songwriters, musicians at various levels. And so you've got a lot of third-party organizations that manage those royalties. You know, you've got BMI, and you've got the Songwriters Guild and so forth. And so if you don't have a plan in place, sometimes it can be difficult to deal with those parties. And so sometimes what we'll do is we'll take those royalties, we'll do some sort of assignment or we'll convey it over to the trust. And then within the trust, we'll dictate who's to receive those royalties and what's to happen with them. I've got a client right now. Her mom married a songwriter from the 50s, 60s, and 70s. He passed away. The royalties came over to his wife, and now she is just pulling her hair out, trying to deal with all these different companies that deal with the royalties and so forth. Because by the time Mom thought about it, she was practically incapacitated and couldn't really set up anything to deal with it.
Yeah. Well, as you can see, that there are a lot of questions and everybody has an individual need, right? So I think you can appreciate why I thought this would be an important part of your team when you are thinking about investing for commercial real estate. There's that honeymoon phase where you're in the deals and you're underwriting and you're making money, and that's your first property, and you're really not thinking about that. We also own a business brokerage and we help people buy and sell businesses. And oftentimes that is the number one mistake, is people do not begin with the end in mind. And how do you set up the business or the asset so that when things go badly, and it might be that you have a partnership divorce, how do you deal with that? Also, in the event that most banks require, for the purpose of the loan, that there is an insurance policy on the members of the group. But beyond that, outside of the insurance, how are the debts going to be handled? Right? And if there is an inherency, who is going to be responsible for the mortgage? Who's going to be responsible for the debt? If there is a business and there's a cash call, and you have a partnership agreement and their tenancy in common, that person how's it written that they're going to, if cash is going to be needed for an infusion, right? So those are all really important issues, and I think it's really important. Justin, thank you so much for being here. Do y'all have general questions? Obviously, he's not going to practice law in group setting, but I would highly recommend that if you don't have an estate lawyer at this point, hopefully he has demonstrated value to you and maybe brought up some important questions that you need to have. If you have a general question though.
So how do you avoid from, like different lawyers telling you, you gotta do this trust, you gotta do this. I was in Dallas this weekend and they were talking about different trusts, and every time I turn around, there is a new one and there's a new one. So how do you know which one? Because you could tell us, how great the trust is and all that, but that's why people sometimes don't actually get so much into that, because there's so much confusion.
Analysis paralysis.
Yeah, it's so much out there that you feel like, okay, which was the right entity for me to go in, and put the trigger on. I don't have 10 kids. I don't have a lot of money, but I'm concerned. I mean, my next deal, goes out. I want to make sure that I'm in good hands. I want to make sure that I'm doing the right, information on the entities.
Right. So if you talk to 10 lawyers, you probably get 10 different opinions, right? And that's the problem that we encounter. There are some lawyers around here that say, oh, you don't need a trust. All you need is a will. And you know what, when you pass away, just have the family come on back and we'll administer the estate and have it go through probate. And we'll get a nice check at the end of that process. So I think the first thing is to research the lawyers you're talking to, do some independent research on your own about the different types of trusts, you know, get multiple opinions, and then make sure it's someone that you can trust. You know, maybe it's a family friend who's already used this particular attorney. You want to make sure it's someone who's experienced. One of the other things you don't want to do is, because there's a lot of attorneys who practice all areas of law, right? So they'll do your personal injury case, they'll handle your divorce, maybe they'll just handle immigration for someone, and then on top of that, they'll do estate planning. I think estate planning is very important, and it's a very wide area of law. And I personally, I could not imagine doing all these other areas of law and doing estate planning. I mean, I struggle with just staying on top of all the trends and all the changes in estate planning and all the new trusts. That it really takes a lot of time and effort. So you want to make sure it's not a generalist, it's a specialist who knows what they're talking about, someone who's been around for a while in the community, where you can, you know, look at their online reviews, do some independent research, check the state bar, make sure that there's no complaints against them. And so it's all of those things kind of go into that ultimate decision about which attorney to pick.
Thank you.
Yes, sir.
Do you have a suggestion of like when it matters to start doing this? Because if you don't have anything, then I don't need to set up a trust, right? But is there a wealth threshold or that you usually recommend, or a business ownership threshold that you recommend when it becomes relevant to think about this?
Great question. So estate planning comes in stages or varying levels, right? So if I don't have anything, right? But I'm an individual and I've got my bills, and maybe I've got a house and I've got a mortgage payment. I need something in place so that if I'm incapacitated, that my mortgage is still going to get paid, or if I'm married and I've got kids, that there's a mechanism in place where they're going to be taken care of. And so maybe if you're a young person, not married, no kids, maybe you start with kind of a will, financial power of attorney, advance directive. But then as you're, you know, getting married, having kids, you bought a home, you're starting to, you know, pay down the mortgage, then yeah, I think that might be an appropriate time for maybe a more basic revocable living trust. And then as you're getting into the commercial real estate market, you've got a property or two, then maybe that's at the point where you do a more advanced planning. Maybe you look at an asset protection trust, or you look at an LLC. But I think you start simple and then you kind of build onto it over time. One mistake people have is they think that estate planning is like a one-time event. Well, life changes. Your assets are going to change. Your relationships are going to change. You're going to change. The causes that you support, your friends, the family, your health, all those things are going to change over time. And so you've got to, you know, maintain that estate plan as life changes.
So what is the age that your kids, because just because you have, when your children turn 18, if they don't have an advanced health directive, can you make decisions for them?
No, not even before they turn 18. Sometimes they're, you know, teenagers, maybe they're in high school and they have a health event. You're trying to talk to or they went to see the doctor, and you want to know what the conversation was like with the doctor or with their counselor or with a psychiatrist, and they're going to turn you away many times, especially when they turn 18. You're trying to talk to their doctors. They're going to say, well, come back with a financial, or actually an advanced healthcare directive to be able to receive the medical information. Or maybe we send the kids off to college and we're trying to fill out their FAFSA application, or trying to make some other financial decisions for them. Then, you know, we need that financial power of attorney. So I have a lot of people who come in as the kids are approaching the 18th birthday or in high school, about to head off to college, and we'll at least do a financial power of attorney and advance directive. And the last one I did, we even did a will, so that it was clear that if something did happen, that whatever this individual had, it went back to her parents or whoever she chose. And then if we've got, you know, both the parents still involved in the child's life, and sometimes we'll name both of them to be able to talk to the doctor, receive the medical information, make the medical decisions, make the financial decisions for them.
So you practice law in California,
Yes.
and now you practice here. So obviously they've got tons of red tape, would you say are the top two biggest differences?
The big difference is, well, California, they have a form for everything, a very long convoluted form. And so it's easy to make mistakes. It's easy not to check the right box or not the right I across the right T. And so it is a little bit more complicated, but the probate process overall is the same. The execution of wills is very different in Tennessee, whereas in California, you've got a will, you sign it, it's witnessed by two disinterested people, and you're good. Well, in Tennessee, they require an additional document called an affidavit to prove the will. So where the witnesses need to sign again and then have their signatures notarized. So sometimes we'll have people move to Tennessee from California, they pass away, we got this California will, but it's not valid unless we can go hunt down these witnesses from 20 years ago and get them to sign an affidavit saying, yeah, that I was there when they signed the will. So that's one issue. And then we have very specific language in our advanced directive for healthcare. California is a community property state, which is very different from Tennessee, which is a common law separate property state. So in California, the presumption is that all assets acquired during the marriage are community, meaning each spouse owns a 50% interest in that asset. Tennessee, we default to separate property. And so we kind of default to how title
That's
is.
kind of a big
Yeah,
deal.
yeah, and we
Big
default
difference.
to how title is held. Right, so in California, a husband passes away, he's the sole title owner on a piece of property. Well, we can go to court on a fairly basic petition to say, hey, this is really community property because they bought it during the marriage, and get it over to the wife. In Tennessee, if the husband passes away and title's just in his name, well, it doesn't just go to the wife. Now it's going to be split between the wife and all the children. So that's one big distinction.
Well, Justin, thank you so much for coming. If somebody wants to get a hold of you, how can they get a hold of you?
So the website, musiccityestatelaw.com. I've got some cards and some pamphlets out there.
Yeah.
So we're pretty accessible on the web.
I think.
Yeah.
We have a gift for both of our speakers tonight.
Oh.
And the other thing I wanted to say real quick too is we have, let's see, 1, 2, 3, 4, 5, 6. We have like 6 people that are, I think, are first time here with us. So we, 7 over there, sorry. Yeah, so we appreciate all of you guys coming out. So,
Thank you. Can we ever come up here, Andy? I want to give you these, but can we get a big round of applause for both of our speakers?
Make sure you grab a cheesecake.
As you can see, we are so blessed to have amazing talent in the Nashville area and people who have a generosity of spirit to be willing to share what they know, and for you to be able to have a taste of the ice cream if you want, to be able to learn from them. But if you want to get to know more and you want to hire Andy, or if you want to hire Justin, reach out. Their contact information is going to be made available. Again, we want to invite you to improve your standard of living, and we provide you with the tools. We give you access to deals that you would not otherwise have, and we help you walk alongside you throughout that process, and we introduce you to team members. But the reason why we do it is so that we improve your standard of living, so that you will improve your standard of giving. And we want to thank you for being here tonight, and thank you so much to our speakers.